Supporters of former President Donald Trump's bid to win re-election to the White House are already frustrated enough with the likes of Alvin Bragg, Jack Smith, and Fannie Willis, who they perceive to be engaging in lawfare against the former president. But supporters of Donald Trump now have an even bigger problem. Could it be that an often overlooked clause of one of the post Civil War Reconstruction Amendments prevent Donald Trump from coming back to the White House? Hang on, folks. We're going to get into all that here in just 1 second. My name is Brian Trippett. I am your front porch conservative. Step on up to my electronic front porch and let's talk. Up to now, most of the efforts against Donald Trump's bid to return to the White House have been in the field of the political or the judicial. And by judicial, I mean that you have had district attorneys or special prosecutors in various parts of the country bringing charges and indictments against the former president. However, there has been an effort among academics to try and find a way to keep Donald Trump from coming back to the White House. For quite some time now, there's been an argument sort of circulating in academic circles about a theory of disqualification. In other words, there's a clause in the Constitution that would prevent someone like Donald Trump from being put back into the White House if he were elected. Now, most of this, as I said up until now, has been very quiet in academic circles. But about a week ago, an article was published by two constitutional professors. William Baud and Michael Stokes Paulson joined together to pen the article The Sweep and Force of Section 3. It was published in the University of Pennsylvania Law Review. Now, it's about 126 pages. We're not going to obviously read all that here, but just know this is the genesis of the public discussion of this disqualification argument. Now, what is Section 3? What specifically are they referring to? What they're referring to is the 14th Amendment. Now, for those of you who may not remember what the 14th Amendment does, it basically is this. To summarize, the 14th Amendment to the U.S. Constitution was ratified July 9, 1868, and granted citizenship to all persons born or naturalized in the United States, including former slaves who had been emancipated after the Civil War. It forbids states from making or enforcing any law that abridges the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life or liberty or property without due process of law, nor deny to any person within its jurisdiction the equal protections of the law. This amendment generally explains the protection of civil rights to all Americans and is cited in more litigation than any other amendment. It also prohibited former Confederate states from repaying war debts and compensating former slave owners for the emancipation of their enslaved people. Finally, it granted Congress the power to enforce this amendment, which led to the passage of other landmark legislation in the 20th century, including the Civil Rights Act of 1964 and the Voting Rights Act of 1965. Now, you read all that and you think to yourself, but front porch, how does any of that possibly prevent Donald Trump from being able to go back to the presidency? There's one provision that little summary overlooks. And frankly, it's a provision that most people overlook because it's hardly ever discussed anymore. Let's go directly to the 14th Amendment itself. Take a look at this. Everything that I just mentioned a moment ago was taken care of in that summary, except for one part of the 14th Amendment, and that is Section 3. No person shall be a senator or representative in Congress, or elector of president or vice president, or hold any office, civil or military, under the United States or under any state who, having previously taken an oath as a member of Congress, or as an officer of the United States, or as a member of any state legislature, or as an executive or judicial officer of any state, to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. But Congress may, by a vote of 2/3 of each house, remove such disability. Now, as I say, this clause is often overlooked, and there's a simple reason for that. By most people's accounting, or by most people's understanding of it, it applied specifically to former Confederate soldiers who had fought against the United States. In other words, if there were officers of the Union Army who had renounced their oath, taken up arms against the government of the United States, this prohibited them from being elected to office because they had engaged in insurrection or rebellion against the same. What is being argued is that Donald Trump should be disqualified from the presidency on the grounds of January 6th. He helped lead an insurrection against the government of the United States. Now, lest you think that sounds far-fetched and is a real stretch of Section 3 of the 14th Amendment, as I said, this thing is starting to gain ground in academic circles, and it's being pushed in mainstream media. You think I'm wrong about this? Take a look at the following. This was published in the Atlantic magazine over the weekend. The Constitution prohibits Trump from ever being president again. Opinion by Michael J. Luttig, and there's another author not listed, Lawrence Tribe. Now, you might recognize the name Lawrence Tribe, very famous professor of constitutional law at Harvard University. His counterpart in this article, J. Michael Luttig, is a former appeals court judge of the Fourth Circuit of the United States. He was first appointed in 1991 under George Herbert Walker Bush, and for many years, when George W. Bush was president, Luttig's name was mentioned as a possible Supreme Court nominee, but it never panned out for him. He's now in private practice. But Luttig and Lawrence Tribe got together and put this article together. I want to read some parts of this. First paragraph. As students of the United States Constitution for many decades, one of us as a U.S. Court of Appeals judge, the other as a professor of constitutional law, and both as constitutional advocates, scholars, and practitioners, we long ago came to the conclusion that the 14th Amendment, the amendment ratified in 1868 that represents our nation's second founding and a new birth of freedom, contains within it a protection against the dissolution of the Republic by a treasonous president. Moving on a little bit further, the historically unprecedented federal and state indictments of former President Donald Trump have prompted many to ask whether his conviction pursuant to any or all of these indictments would be either necessary or sufficient to deny him the office of the presidency in 2024. Having thought long and deeply about the text, history, and purpose of the 14th Amendment's disqualification clause for much of our professional careers, both of us have concluded some years ago that, in fact, a conviction would be beside the point. The disqualification clause operates independently of any such criminal proceedings and, indeed, also independently of impeachment proceedings and of congressional legislation. The clause was designed to operate directly and immediately upon those who betray their oath to the Constitution, whether by taking up arms to overturn our government or by waging war on our government by attempting to overturn a presidential election through a bloodless coup. The former president's efforts to overturn the 2020 presidential election and the resulting attack on the U.S. Capitol place him squarely within the ambit of the disqualification clause, and he is therefore ineligible to serve as president ever again. The most pressing constitutional question facing our country at this moment, then, is whether we will abide by this clear command of the 14th Amendment's disqualification clause. Okay, that's a lot to get through, so let's break this down a little bit. Basically, what Ludig and Lawrence Tribe are saying is this: look, you don't even need a conviction on all these other charges that are being brought. You don't even need an impeachment. You don't need almost anything. The fact that Donald Trump was involved in an insurrection against the government of the United States and tried to overturn the results of the 2020 election makes him disqualified under Section 3 of the 14th Amendment. He engaged in insurrection and or rebellion against the government of the United States after having taken an oath to uphold said Constitution of the government of the United States. Okay. That's the argument why Trump should be disqualified, and that's the basis on which they're doing it. Section 3 of the 14th Amendment. Now, as you might suspect, there are people on the other side of this argument who are saying hogwash. And frankly, I'm inclined to agree with them, and I'll explain why a little bit later. Let's go to an article written by Jonathan Turley, Constitution article in thehill.com. The disqualification of Donald Trump and other legal urban legends. You got to give Turley this. He's got panache. The popularity of urban legends is a testament to the will to believe, the desire of people to keep Elvis alive or to prove that a Sasquatch could exist furtively in our backyard shows the resilience of fables. Constitutional urban legends often have even more immediate appeal and tend to arise out of the desperation of divided times. One of the most popular today is that the former President Donald Trump can be barred from office even if he is not convicted in any of the 4 indictments he faces under a long-dormant clause of the 14th Amendment. The 14th Amendment theory is something the good liberals will read to their children at night. It goes like this: Donald Trump can never be president again because the 14th Amendment bars those who previously took federal oaths from assuming if they engaged in insurrection or rebellion. With that, and a kiss on the forehead, a progressive child can sleep peacefully through the night. I have strongly rejected this interpretation for years, so it is too late to pretend that I view this as a plausible argument. However, some serious and smart people take an equally strong position in support of the theory. Indeed, conservative scholars William Baud and Michael Stokes Paulson have argued that the interpretation and insist in a recent law review article the case is not even close. All those who are committed to the Constitution should take note and say so. But some of us like to believe that we are committed to the Constitution, and for the same reasons we say no. Despite my respect for these academics, I simply fail to see how the text, history, or purpose of the 14th Amendment even remotely favors this view. Despite the extensive research by Baud and Paulson, their analysis ends where it begins. Was January 6th an insurrection or rebellion? Okay. Turley makes a fantastic point. In order for this argument to stick, you have got to be able to prove beyond the shadow of a doubt that what happened on January 6, 2021 was indeed an insurrection against the established government of the United States. Well, I've heard enough lawyers, be they liberals, conservatives, or somewhere straight down the middle, say, no, it is not an insurrection because it doesn't fit the legal definition of insurrection. It doesn't fit the practical definition of insurrection. Look, this was a protest gone bad on so many different levels. As a matter of fact, Turley argues the same thing further into his argument. And frankly, as much of a conservative as I am, and as much as I was in support of the idea of challenging the results of the 2020 election, legally and lawfully, even I admit what happened that day got way out of hand. But there's no way, even though there were people doing things that were just flat out wrong, there's no way that anybody with common sense and basic honesty could say that what that was a rebellion against the government of the United States, or worse yet, a blatant and attempted insurrection. So Turley's right. These scholars may be correct in their interpretation, but it all hangs on one thing. Was January 6th legitimately an insurrection? Turley's saying no. I agree with him. But lest you think that Turley is alone in this opinion, I want to play you a clip from War Room with Steve Bannon. Bannon had on Harvard Emeritus Professor Alan Dershowitz. Take a listen to this analysis of the question about the 14th Amendment.
I've only got a minute here, but I'll hold you through. When they came out with their initial analysis on the 14th Amendment, you said that was dead wrong. That was only about the Civil War. Can you give us a minute on that before we go to break?
Sure. The 14th Amendment is about the Civil War. It talks about not having to pay for emancipated slaves. It talks about not having to pay the debts of the Confederacy, and then it says people who have involved in the revolt, which meant the Civil War. And you didn't need a procedure for that because Confederates were proudly proclaiming their support for the Confederacy. So it was very obvious who fought against the United States. But if you try to project that now, 150, 60 years forward, you need a process, you need a procedure. And the 14th Amendment was designed only to make sure that those who fought in the Civil War against the Union could not run for office.
Okay. And again, historical context matters. If this disqualification clause is what it claims to be, then how come it's never been applied at any other point in history? Because if we're going to make the argument that trying to protest against the results of an election are somehow a basis for disqualification under Section 3 of the 14th Amendment, I can think of a whole lot of people up to now who ought to be out of office or should have been removed when they were in office. And I will spare you the indignity of all the names. But one last argument to consider, and this comes from Robert Barnes. This one's pretty good. Take a look at this. Talking about Ludig and Lawrence Tribe's argument in their article, Barnes says the key problem with this Ludig argument is history. We have already had a presidential candidate who was, unlike Trump, actually charged with and convicted of and in prison for sedition that sought the presidential ballot. 1920, Eugene Debs. He was never denied access to the ballot. Okay. Now, there's something that's unspoken in what Barnes is saying, but his historical analysis is correct. Eugene Debs was tried and convicted of sedition against the government of the United States. But in 1920, he sought the presidency from behind a jail cell, behind bars. Yet he was never denied access to the ballot. Why is that? Well, it's very simple. Let me take you to Article 2, Section 1 of the United States Constitution. This has to do with powers of the president. Listen to this. No person except a natural-born citizen or citizen of the United States at the time of the adoption of this Constitution shall be eligible to the office of president. Neither shall any person be eligible to that office who shall not have attained to the age of 35 years and been 14 years a resident within the United States. Those are the qualifications. And even though Eugene Debs was behind bars in 1920, he met every one of them. Nobody tried to keep Eugene Debs off the ballot, even though he had been tried and convicted of sedition against the government of the United States. Barnes's point is this: doesn't matter. Donald Trump could be convicted of one of these charges, but guess what? You can't deny him access to the ballot because he meets all the constitutional requirements necessary to seek office. So this argument about the 14th Amendment somehow preventing Trump from going to the ballot and going back to the White House, it's hooey. It's ludicrous, but it's going to be pushed, just like the lawfare against Trump, just like the political arguments against Trump. Now you've got an academic argument that's being made. Believe me, folks, whether you're a supporter of Donald Trump, whether you're not a supporter of Donald Trump, you've got to be intellectually honest about one thing. All the stops are being pulled out to make sure that he never sees the White House again. And these things that are being done, I think, are in the long-term detriment of the country for a lot of different reasons. But that's what I think. What do you think? As we start to wrap up this video, please do me some favors as always. Number one, if you are not a subscriber to the channel, please do so. Number two, please leave a comment below. I'd really like to know what you think of this. Number three, please share the video around. It would really help me out a whole lot. Number 4, hit the bell for notifications. I want to make sure you're always aware when new material is coming out. And number 5, please give me a thumbs up. My name is Brian Trippett. I am your front porch conservative, and I'll see you next time.